and I am a staff attorney with Legal Services of Eastern Missouri. We're going to be covering several topics on today. We're going to give you a brief introduction of what my organization does. We're going to cover what is intellectual property. We're going to talk about trademarks and service marks. What are they? Trademark selection, using your trademark and enforcing your trademark rights, trademarks as it relates to your business planning, and potentially becoming a legal services client if you are interested in doing that. So I just first want to verify if everyone can see my screen here. It looks, yes, perfect. So Legal Services of Eastern Missouri is the largest civil not-for-profit law firm in the area. We offer a variety of civil legal services, including in the areas of family law, housing, public benefits. We do some immigration work. We also assist with advocating for students as it relates to education law. We have our NBI program, which we're very proud of because they're doing a lot of great work in the community with reclaiming blighted properties in the city of St. Louis. And now with a micro enterprise program, we actually offer free legal services for aspiring entrepreneurs who are starting their own businesses or not-for-profits. Legal Services has been around for a while in the St. Louis area. We have had the wonderful opportunity to help over 1 million low-income individuals with a variety of civil law issues since 1956. In our program, we help both existing businesses and startups, as well as not-for-profits, as I mentioned, so you don't already have to be organized. We can assist people with getting organized. There are just some basic things that we do ask for, such as a business plan. It can really help businesses to avoid some of those time-consuming legal problems that you can run into if you're starting without really knowing the legalities of operating a business. So we do things from entity formation, helping people apply for tax exempt status as it relates to not-for-profits. We do a lot of contracts work, reviewing them, drafting and negotiating contracts, as well as leases for our clients. We do some intellectual property work and at least giving some general advisement as it relates to it. And in some cases, we do file trademarks. And that's pretty much the only area of intellectual property that will actually open up. And I'll get into what intellectual property is here very shortly. The services that we offer include one-on-one legal representation. We provide legal workshops such as the one that I'm doing today, as well as just giving general legal information and screening for potential clients through our legal office hours. I'm a little behind on mine. So what is intellectual property? I like this graphic here because it just shows the idea thing here, because that's what it is. Intellectual property, it is commercially valuable products or services that are uniquely made using human intelligence. So unique is going to be the key word when it comes to intellectual property. There are lots of different areas, and I'll go over, there are actually just several, I said lots, but the one area, I'll at least just give you a brief overview of the areas that we are not going in depth in, just so you understand the difference between the various types of intellectual property. First, there are patents. Patents are a type of intellectual property that generally cover inventions. So they'll cover things like processes, methods, machines, new composition of matter. So if you somehow came up with some new material that's never been used for and it's beneficial, you can seek a patent for your invention, as well as manufacturing designs. And what a patent does is it gives that patent owner the right to exclude others from making, using, marketing, or offering an invention for sale. There are trade secrets. Trade secrets are confidential. It's basically could be formulas, processes, devices, or other business information that is deemed to be confidential to a business. And then there are copyrights. Copyrights will actually cover original, artistic, and literary works. So that would be books, your websites, any content essentially created, even podcasts would be covered under copyright law. And if you do have more in-depth questions about some of those areas, we do have information in our office that's available to the public, and we'll give you our email address at the end of the presentation if you are seeking a little bit more information about those areas. But today we're going to be covering trademarks, which is a form of protection that covers goods and services. So we'll get a little more into that. So what are trademarks and service marks? You can see here in the background that there are just all types of brands, titles, companies. You see, you're just overwhelmed with all these different things. And so I put that graphics there for a reason, because it represents what trademarks cover. A trademark is a word or words, phrase, logo, or even a symbol that will distinguish a product or service from its competitors. Okay, so a trademark, also called a mark, is like a signature because it tells the public the source of that good. Okay, so if the mark is on the product, it's called a trademark. You can register a trademark as a business or as a not-for-profit. So an individual can own a trademark, or a business can be the owner of the trademark. So that is kind of one thing to keep in mind. Okay, and I'll just want to kind of briefly explain some of the benefits of trademark registration. We'll get there in just a moment. I also want to go over a slight differentiation. It's filed the same way as a trademark, but if you are providing a service instead of a product or a good, it's generally called a service mark. And so that mark can function as both a trademark and service mark. So for example, I was in Best Buy, I'll name drop them, the other day, and I saw the Geek Squad. They had TM next to it. And I was thinking to myself, and my brain and my capacity and what I do, I'm just like, well, isn't Geek Squad isn't it more of services? But they use the TM superscript, and that could be because they offer both services and products. So I don't know, that just, but we have some different brands here. So you'll see, I don't have them all on there, but Amazon has a R superscript with a circle around it, and that means that's a registered trademark, those particular words. Schnucks, it looks like they have a teeny tiny little R. And then we have some other brands, but those are examples of the types of things that you can trademark. So what kinds of things can I trademark? I kind of led right into that. You can trademark a word like Toyota. You can trademark a slogan. And you see that we have the example of Nike's "Just Do It." Okay, so and I see questions popping up, and we'll make sure we get to your questions by the end of the presentation. But just kind of want to give a little bit of background, and we may actually answer some of those questions during the course of the presentation. Symbols, here's a great example of that. Apple, just the symbol of the apple, it's unique and it is connected. When you see that, you know that's an Apple product. Product designs, so even like the little twist, the way that Hershey Kiss is wrapped up, that is a trademark design. Colors, sounds, and even smells can be trademarked. When I found out smells, I thought that was just remarkable. So very interesting area. It can be very exhaustive. Today, we're just kind of going over general, high-level things, and just want to keep it general for small businesses and entrepreneurs. I'm using a lot of examples of large companies because large companies, they make sure that they want to protect their brand. That's one of the reasons that you get a trademark, is because you're protecting a valuable brand. And that doesn't mean that everybody's business is not valuable, not saying that at all. But when I say valuable, I mean commercially valuable. So you're making money off of this name, off of this sound, off of the smell, and you want to protect yourself against others who may come in and try to make money off of your brand. So a business name, Coca-Cola Company, okay, that in and of itself is not probably trademark, but this mark here with the stylized lettering, that is how Coca-Cola has registered their trademark. Now, Coca-Cola, they do have word marks that are registered, just so you know, and that have Coca, I think it has Coca-Cola and whatever their slogan is up under that. So that is also a trademark, but the Coca-Cola Company in and of itself is not trademark, I don't believe, okay? So just kind of want to give an example of things that are not trademarks. I think sometimes people get things confused as in what's what, so I just want to make those differentiations. Your business registration with the Secretary of State, that is not trademark registration. A business license doesn't have anything to do with protecting your brand. That's more in compliance with your local rules and regulations. There are businesses who operate under fictitious names, and there's probably the least amount of protection in just having a fictitious name without having your company officially registered as either a LLC or a corporation, because there are some maybe states' rights that may come into play once you do that, but that's still not the same as trademark registration, as well as domain name registrations. A lot of people may get that confused. They think once they register a domain name, you know, that you definitely own that domain, but that doesn't necessarily prevent someone from coming behind and maybe trademarking that if you haven't went through that process. So these are just things to be aware of. I'm going down to the next slide here. So let's talk about selecting your trademark. The things that are most important that you want to keep in mind when you are choosing your trademark is you want to make sure that whatever mark you're choosing, whether it be a symbol, whether it be a logo, slogan, or just even if you're trying to trademark your company name, you don't want it to be confused with other products or services, okay? And then you also, the next thing is what's the strength of that mark, okay? And that's something generally an attorney could assist you with, because trademark is a very specialized area, I'll say that. And there are many different ways to search for whether or not a name is already taken, what's available out there. So in terms of talking about the likelihood of confusion, one of the biggest things that I start with my clients is looking at what area is a person getting into, like what industry. That's one of the things that you're going to have to go through when you are registering for a trademark, is actually specifying what service industry you're in, what types of goods you're selling. So if you're selling more than one type of good, you're going to want to make sure that you're listing all of those goods, because that's going to be taken into account in that analysis as to whether or not there's a likelihood of confusion when it comes down to trademark registration. So I just essentially just have the definition of what is a likelihood of confusion as deemed by the USPTO, or the United States Patent and Trademark Office, likelihood of confusion between your mark and a mark in which another party already has rights through prior use or registration. So that prior use is the big one, pretty much in what I was just saying. So marks that look similar. If it is an actual logo that we're talking about, or a sound, if it sounds alike and you're trying to trademark a particular sound, if they sound too much alike, if they have a similar meaning, do they create similar commercial impressions? That's a very big part of that likelihood of confusion. And what that makes me think of, just as a little sidebar, I don't know if anybody remembers that movie Coming to America. And you remember how there was that McDowell's, and it's so much like McDonald's. I mean, everything about it that let us know that they were kind of a play on McDonald's. So that would not go over well, I can tell you, if someone tried to probably start one of those chains, because the goods and services are related, okay, in such a way that some consumers may be likely to mistake and believe that those goods and services come from the same source. So you don't want that. You don't want to have a similar name and a similar industry. That would likely result in your trademark being rejected. And so just another example of a likelihood of confusion as it relates to a sound. If your mark is, say, as you see on the screen here, T Markey, and there is already a registered mark, T Markey, even though they're spelled completely differently, they sound alike. So that could raise an issue for the person who is coming second in time, trying to file a trademark. Okay, likelihood of confusion as it relates to the appearance of the mark. So we have T Markey spelled the same way, but one is stylized letters. Well, if there's already, that exact same word that's registered with stylized letters, it's going to be hard to come in behind that and just come up with the general letters. I mean, that would be an easy argument that people could confuse those products or services and believe that they come from the same source. All right, commercial impression. Okay, so even though in these examples you don't have both the name T Markey and the symbol or this commercial logo in the background, if you just use that logo without the words, people are still going to be likely to believe that the services or products are coming from the same source. So those are the types of things you have to be very careful of. And that can be, I'll just be very honest on that, that can be very difficult when it comes down to logos. When you're searching that, in my opinion, it takes a little bit of expertise in searching for those marks, because you have to know terms or find the terms to describe this particular mark in the USPTO database. So you'll have to come up with different search terms, circle, R, just different things like that. So just kind of know that if you're looking to do a logo, I highly recommend seeking the assistance of an attorney as it relates to that. As it comes down to the likelihood of confusion with similar goods and services, let's say I have a name or something that sounds very similar to another, and I'm selling t-shirts and pants, and that other service, they're an online retail service store, okay, and they feature clothing. So those two similarities kind of coupled with maybe either the marks or words sounding alike would definitely cause a likelihood of confusion, which would weaken the strength of your trademark. So that's what I'm going into here, or the strength of your trademark application. Let me say that. And so this next section, we're talking about the strength of trademarks. The more distinctive your mark is, the greater the level of legal protectability. So let's just keep that in mind. Okay, so the more generic the mark is that you're seeking to register, the less likely it may be to either get the trademark in the first place, just kind of depends. But the more specific your mark is, the more unique, the more distinctive, as this picture kind of demonstrates, the more levels of protection that you will be able to have with your trademark. Okay, so how do you assess the strength of the trademark? And so I've kind of been talking about that a little bit, but as I said, there are many different aspects to assessing that strength. You have to do some research on the strength of your mark, as well as the strength of the potentially conflicting marks. That's that work that I pretty much recommend that you have an attorney do, because there are actually very specialized databases in which attorneys and people who specialize in this field can look in to assess the strength of your mark. Okay, you have to also assess the validity of a mark. So I'm going to kind of get into the specifics of what I mean by that. Okay, when you're doing your research on the strength and scope of your mark, you're going to, that's dealing with the nature, extent, and duration of your use of the mark. So let's say there are two people with similar types of businesses, kind of same name. Sometimes it's the same, sometimes it's similar names. When you're looking to register the trademark, even though you see that there's someone who could potentially have a conflicting name or something that would just cause problems for you later on down the line, you want to look at how long have they been using that. If you've been using it for 10 years and they just, you know, all of a sudden popped up maybe with a website or something on social media within the last year, that doesn't necessarily knock you out of the game, even if they filed first. So, I mean, it can really become a race of sorts. Okay, so you're looking at what's the extent of consumer recognition of that mark. And one of the things that I'll look at when I say that is it a product or service that is local? Is it just in one city? Is it statewide? Is it nationwide? Is it worldwide? I mean, if it's something that's being used worldwide and they can show that they're using this mark in commerce, the more use, the stronger their argument may become in gaining that trademark. Okay, and as well as the existence of other users of similar marks for the same or similar goods or services. So those are some of the aspects of when you're researching the strength and the scope of your mark. What other types of businesses have similar marks, similar names, and what do they do? You want to make sure that you're looking at that, because if they do something completely different, that again can kind of strengthen your argument to gain a trademark in another area or a service mark. In terms of the validity of the mark, if there is a mark that's federally registered or with the state, okay, you can check on that. You can check on the USPTO and verify whether or not a mark is on the principal register and in what category. So what categories of goods or services. And like I said, it can get exhaustive, but I will say this about the USPTO website. They have a ton of really helpful information that will even just kind of give you basic information that will assist you with your research even before you go and talk to an attorney. And thank you for posting that link. Okay, and I'll just just to kind of break up from just me talking, I just saw the last question, I think, was, would a photographer need a service or a trademark? Honestly, I mean, it's a personal decision. It depends on the commercial um, value, I guess, of that particular enterprise. If you're a sole proprietor, I I'll say this, it depends. That's the answer us lawyers like to give. If you already have a logo, it depends on what you're trying to trademark. Are you trying to trademark your name? You're trying to trademark a logo? Are you doing work nationwide? Are you just doing work local? Have you been like really scaling in this business and you have some type of mark that is really setting you apart from your competition? Though, to me, those are the types of reasons an individual will have to really make that a priority if you're a sole proprietor or a small business, okay? And, of course, like I said, there are certain benefits. You're going to get that legal presumption of ownership and right to use that mark. If you're registering, because you really want to prevent other people from using that mark. You have that legal right to enforce the mark through legal action in federal court. But you can also still send people cease and desist, okay, if you are using some common law trademark protection, such as just putting the TM or the SM after your logo or your whatever mark it is that you're trying to protect, okay? And that's another way of putting the public on notice without actually having to file with the USPTO's office your federal trademark, okay? So the legal action that you could take and your rights that you could enforce just probably wouldn't be in federal court if there was some other local person that was trying to steal your brand or hold themselves out as being you or using your logo or something like that. So that's why I say it's a depends, but for the most part, I don't see the necessity to get a federal trademark if you're a local photographer. Now, if you have some type of enterprise that's online and you're franchising, things like that, that's what I mean when I say commercially valuable. And now you're on the online and you have how people are online. Once they see things, they can try to take them. So, and it's the same thing even with a local business. A local business obviously can have a website. And if you just feel that your branding is so unique and so connected to that service or product that you provide, and you're fearful that someone will try to capitalize on that property, intellectual property that you deem to be yours, then federal registration may be something that you can see, but you have options, okay? So remember, you have the option of common law protection, just using that TM or SM superscript after the mark you're trying to protect, and there's also state level registration. Okay, so hope that kind of broke up a little bit and then had a chance to kind of get one of the questions out of the way. But I'm going to go back to what I was talking about was the strength of your trademark and how distinctive is your mark. Is it fanciful? I like that word. Arbitrary or suggestive? So those are some of the things that can make a mark, distinctive, such as that Coca-Cola, that distinctive cursive writing. Even if you're far away and you can't even really read the words, that's Coca-Cola. Okay. And that kind of takes me to that next part, which is, has the mark acquired customer recognition for descriptive marks or a product configuration? Okay, so yeah, is whatever the mark is it something that has acquired that customer recognition, like that Apple symbol? And has that mark been used appropriately? Now, that's a big part of trademark registration, okay? Because we try to tell people, if you're going to file a trademark, know that you actually have to use it. You can't just, hoard the a certain business name or a certain phrase, and then you're not using it in commerce. It's not connected to goods and service in commerce. So that means you're not making money on it. That you're not selling products, you're not providing services using that mark. If you do that, you are going to risk losing your trademark. So here's some best practices as it relates to trademarks. Make sure that you clear that mark prior to common law use or even filing an application. And there are some different ways in which lay folks can do that. You can Google. Google always works. You can, excuse me. Okay, excuse me. Yeah, so yeah, you can always Google. You can definitely search the terms on the USPTO website. Make sure you do that. That's pretty simple. But like I said, when it comes to the logos and marks, symbols, things like that, it can get a little tricky. What you don't want to do is assume that the registration of your business name is just automatically giving you the rights to use that name as a mark or as a trademark, okay? So make sure you do at least that general research. A lot of times a Google search can really tell you a lot about what other types of companies or services might be out there operating, and you'll have an idea before you really even decide on your name. So that's definitely like one of the big things that I tell people. Another thing that you want to do is make sure that your marks are distinctive. Try to make something unique about that symbol or logo. And I was just trying to think of an example. Like there are a lot of, like, let's say, if you're using like caricatures or something like that, be careful when you're looking for similar products or marks of similar products or services, because it can be very generalized. Even if one character doesn't look just like that next character, you can say, well, mine is wearing glasses and theirs is not. There's still been times where they're like, nope, too similar, because you're operating in the same industry. So, so try not to adopt a mark that is not very distinctive, all right? Do make sure that you're considering registering your mark at the appropriate stage in business development. And what I mean by that is, like, there's nothing wrong with looking into getting this general information, like if you haven't even started your business yet, but this is like definitely, I would say, at the bottom of your to-do list. Getting started, registering your business, and becoming profitable are definitely priorities that I would, kind of warn people against, just making sure that you're staying focused on that before you're going straight to intellectual property, because filing can be costly, okay? You also don't want, on the other extreme, you don't want to wait too long, okay? Because it may allow someone else to gain rights through using that mark, or simply even by registering, okay? In that file too soon category, there's also something else to think about as it relates to your filing basis. You have to have a filing basis as well. In addition to saying, hey, this is mine, I want to protect it, you're either filing under the basis that you are using the mark or that you have the intent to use it. But when you file an intent to use application, you're doubling the cost of your filing, because you're going to have to provide additional information to show that you are actually using it in commerce. And a lot of times that's how a lot of people end up abandoning their trademark applications, by not following up with that. So all things to consider, making sure that you file your application for registration in your registered business name if you want your business to own it, as opposed to just you as an individual, okay? And so, yeah, if that is what you want and you want those assets, because intellectual property is an asset, if you want that to belong to your business, make sure that you're not filing the application in the name of an individual. Okay. Consider very carefully what goods and services should be covered. Okay. One thing that will make that part a little easier for you is when you are doing your business planning, when you're setting your business plan. A lot of times you'll have goals. You may start off with just certain limited services and products, but then you may have it in your business plan and already spelled out how you're going to reach that next step and you're expanding in products or services. So if you are planning on following that, and hopefully maybe even by the time you file it, because you're not doing it too soon, you're already doing those things. But you want to make sure that you're being as exhaustive as possible to have as much connected to that mark as possible. Okay. So if you don't do that, you may fail to cover some of your core goods or services. So that's that. Trademark clearance searches. So I talked a little bit about that already. I got a little ahead of myself. But yeah, just that basic screening is going to be doing the Google search and looking on uspto.gov. But the comprehensive, and I think the best thing to do is to seek the services of a trademark professional. So we here at Legal Services, we are more general practitioners, general business practitioners. We don't hold ourselves out there to be trademark experts, but we do assist people with trademark issues and matters. And from time to time, we may provide a little bit more expanded services, but you want to get that professional search is what I'm getting to here. There are all types of databases out there, and some of them are free, but the thing is, do you know about these services? And a lot of us don't. A lot of us lawyers don't know about all of the trademark search mechanisms. There are different programs and software that lawyers can use, and it can be quite costly. So as you see, it can run you $1,000 or more. Okay, and that's just to kind of get your mind ready for what it could be if you're really going down this road. So we're going to talk a little bit about trademark use and enforcement. Okay. So again, I got a little ahead of myself and I talked a little bit about some of the levels of trademark protection. Talked about that common law protection, and the requirements for that is just simply use your mark in commerce and label your products. So if you have a product, that's a big thing, is putting that that TM on the label, okay? And instead of labeling your product with an SM, that's more than likely going to be where you are holding your services out to the public. So your website, you want to make sure you're putting SM behind your service name. The benefits that you have is, again, it gives you the right to use your mark in commerce, and it's putting people on notice that you intend to protect that brand. Okay. Protection is limited to your current market area only. So if you do that, this is for individuals who are more local, okay? That's going to protect you more like statewide or more in the area. So your protection is going to be very narrow, but that's okay for many small businesses and not-for-profits. Many not-for-profits have a local mission, or businesses are just serving a local community. So they're not looking for international registration necessarily. Okay, you can register your trademark through the state of Missouri. Okay, you have to use, again, the requirements are going to be pretty much the same for all of them. You're going to have to use that mark. The other thing I would say about common law and statewide registration, there is no really intend to use. I think you have to be using that mark, okay, in the course of your business. So that's one differentiation, a big differentiation. But some of your benefits to state registration is that they can provide some protection from infringement in your current market area. And the cost is very relatively low, I would say $55 per class. And then let me just also kind of expound on that per class issue. So when I was saying, make sure you encompass all of your goods or services. So if you have a few different service areas that are in different categories on the trademark, in the trademark database, then you are paying $55 per class. If you're wanting to trademark both a logo and some other stylized writing, those are two different things. So every little thing that you're breaking down, that's going to be $55 per class. And as you can see with the federal registration, it's a lot higher. Okay, the benefits is that you're going to get some nationwide protection for your mark, but it's going to be about $250 per class, and that's if you do what they call T's plus. That's the application that requires a little bit more information, more specific information, which is why it's likely going to be more beneficial to have an attorney, which are T's plus, but the filing the application itself is cheaper. If you do the regular T's, I believe that's around $400. But what it does, you have to at least intend to use your mark in interstate commerce. So that's the other biggie that I would point out as it relates to federal registration. Okay. So just to give you an illustration of how this looks, okay? When you are trying to use that mark, okay, let's say you file and you want to show that use, you want to make sure you're actually putting your mark. If this mark that I'm circling around, hopefully big enough for everyone to see, if that is what you're trying to trademark, you need to have that on your product if it's a product that you're selling. You want to put it on your product packaging, tags, labels, nameplates, even, invoices, but I think the products is the biggest thing when you're doing products. Or your services. Services, the letterhead, little iffy, I like invoices because it shows you actually see that there's some value being exchanged for my service. Now, that letterhead is good if maybe what's in the letter is showing an exchange of service for money. So you're showing that you're using your service in commerce. You can use that mark as well on signs, manuals, brochures, and advertisements. Okay. Let me catch up here. All right. So protecting your trademark. So the thing is, if you're saying that someone is infringing on your trademark, what you're trying to mark as your trademark or file as your trademark, you're looking at is there the likelihood of confusion? Does this other mark that you feel like, oh, that's mine, or they got that from me, is it similar in appearance to the way your mark is? Is it similar in the way it sounds, what it means, or that commercial impression? Like, for example, I've had people tell me like, oh, I've worked with someone before and they went off and they started their own business, which is similar to mine. And it has a similar symbol in their logo, so that something like that impression, that's the commercial impression. Is it the same type of service and there's something that's either the same or just eerily similar? You could make a commercial impression argument. As it relates to the similarity of the goods and services, if one person is saying, well, she was a makeup application service and I sell makeup products. It's still in the same general area, so that there's still some similarity. What's the strength of a mark? Those are the things you want to look at and say that your mark is stronger because you've been using it longer. Those are some of those things when you are looking at those infringement standards. If you're operating in similar marketing channels, again, like we're in the same market, we're providing as a not-for-profit, let's use, a not-for-profit, for example. We both do similar marketing. We both work with United Way. Both of our services are accessible through that way. And their agency is sounding just like my agency, or it pretty much means the same thing as what the name of my mark means, but they're saying it in a different way. Those are some of the things that you can argue that a mark is infringing on yours, okay? Or actual instances of confusion. Those are really strong, that's strong evidence. If you're constantly getting, your customers are telling you, hey, every time I try to look you up, I keep getting this other business that's spelled almost like yours, except for one difference, like one letter is different. And I end up calling them and I almost ordered, from them. That would be a really strong example. And so I'm sorry, I know that we are winding down. So I'm gonna try to keep it moving here. So how do you enforce it? You get to enforce it, okay? You have that duty really to police or protect your trademark. I mean, these large companies, they have whole departments that are look like Coca-Cola. I keep using them, but it's easy to use them. They have a huge IP department. Also, you want to, as an individual, you can watch out by looking on the internet, trying internet searches every once in a while. If you see someone using your letter, you can send a cease and desist letter. If they don't cease and desist using your mark, you can consult with an attorney and see what your next steps can be. If you go to register your mark and you see that a similar mark has been registered very recently, but you've been using yours for much longer, you can potentially have the right to file an opposition or to file to cancel that trademark. You can file a lawsuit and you can seek damages for those things. So those are all things to keep in mind. So we talked about trademarks and business planning. And I like that showing, it shows, your brand. That's pretty much what trademarking is about. It's about your branding, protecting your brand. It's important to think about it early on and maybe incorporate it into your business plan if it's something that if you've come up with this really great idea, maybe have that as part of your business plan. Some of those things you want to ask is, how much time and money do you have to spend on this? So like, what are the expenses? If you're a small business, you might just say, you know what, I'm just going to file in this one class for right now, okay? Because I'm small and I'm profitable, but I'm not quite scaling the way I want to, but I know that this brand is super valuable. I know I'm going places. Yeah, you can go ahead and incorporate that into your business plan. And you can even put in your plan, like what phases. First, I want to file in these two classes or categories. And then 5 years from now, I hope to expand my intellectual property portfolio. So those are things that you can plan for. Putting it in your budget. I mean, that's one of the reasons you would want to think about it early on. So you want to think about how much money would I need to do what I think I need to do to protect my brand, okay? Is it necessary to do it now? To me, that's really the biggest questions for small business owners and not-for-profits. And I think most of the time the answer is no. Now, when you look and if you see that there's someone that's already filed, you might want to get on that as soon as possible, but you have to be using it in commerce. And that's the only way you would be able to oppose or cancel it anyway, is if you've already been using that in commerce. So that's a little bit maybe further outside of the scope of business planning, but that timing aspect is definitely something to keep in mind when thinking of filing a trademark. Okay, I already talked about, can you add additional protections later? And where are you actually operating? Gosh, that's a big one. I've seen a lot of people that have been really insistent on filing a federal trademark for services that are pretty local. I mean, like really for the most part local. Um, so I think you really have to think about that. Is it worth it? Is that worth coming out of your profits as a small business to file for these protections if you may not really plan on using it much outside of certain locality? All right. So some of the things you need to think about. Do you own the mark? I know we're running short on time. Okay, if you aren't a graphic designer, more than likely you hired someone to design a logo for you. I've known a lot of people who design their own, which is really impressive to me. And it makes it easy because you're the default owner of that logo, or whoever creates something, you're the default owner. So what you want to do is make sure you have an assignment of rights contract with your designer. Many times designers will already have some type of service agreement or something like that, but they may not always have really like a full statement in there about you getting the full rights to use that logo in whatever way you choose. Or that says that you are the owner. That's the important part, that you have full rights and you are the owner. All right. If you are planning too broad with your business plan, okay, this just speaks back to what I was saying, okay? You're planning to offer an event planning business, but also selling wedding candles and running a small shop, adding a trademark, that can be like 3 different classes, 3 times the cost. What's your main business? That's how you can prioritize that decision. And have you created a brand before confirming you aren't violating anyone else's trademarks? That's the biggie. That's all we say. If try to do that early on, but if you haven't done that, you're already operating, it's not too late to look. Okay. And it's never too late to rebrand. That's another reason why I caution people about trying to file too soon, because if you're a brand new business, there's a high likelihood that you may rebrand, and you'll have to file those trademark fees again for the new mark that you want. So keep that in mind. Determine what protections you want. Keep in mind that property is a business asset. Make sure you budget your expenses related to your goals. As you expand your sales regions, you can always update your business plan and come back to that idea of federal registration. And don't develop more branding than you can enforce at the beginning. Does that make sense? And when I say that, that just means some people are just kind of all over the place. And if you're not going to be using it, you might not be wanting to spend that much time. So I'm down to just a couple of minutes to talking to you about how, and we're still going to see if anybody has any other questions I didn't answer. You see our email address. If you have questions or wanted more information on the other types of intellectual property, feel free to email us at ced@lsem.org or give us a call. Our St. Louis County residents, you can call 256-8795. City is 256-8752. Just make sure you have a completed business plan. If you're a not-for-profit, you can also do a not-for-profit business plan, and we like to see that. There are financial qualifications that we can give you more information on later and that I have detailed on the screen. I'm going to take a look at the chat to see what other questions I may have missed. What if someone else has trademarked the words you may want to use as your business name? Is the trademark local or all federal? I'm hoping that I have answered that question, maybe, but just to kind of wrap it up, it depends. I'm sorry, I know people hate that answer, but yeah, it depends. How long have you been using that name? But you said you may want to use. If you haven't started the business yet and someone else has already trademarked that exact name, what I would think about is my business operating in the same area as it is? And there's a couple things I mean by area, geographic area, but more importantly, service or product area. That's the biggest thing. If it's the same service or product area, I would caution against starting a business and building your brand using the same name as someone else. I hope that answers that question. And I did talk about the difference between federal, so the trademark registration versus state and common law. So that question was more towards the beginning of the presentation. I'm hoping that that question has been addressed. I don't see any other questions at this time. And it's 12 o'clock on the dot. So thank you everyone for tuning in. I wish everyone the best of luck with your brands, your business. Just make sure that you follow the advice that we gave out today. If you need additional information, please do not hesitate to reach out to our program. Thank you very much.
Thank you, Stephanie, and thank you everyone for joining us. Thank you, Stephanie, for your wonderful presentation.
Thank
you. You've addressed the questions that we had, and I thank you all for spending time with us. I'm going to enter in our chat box some of the couple of links that you might find useful. The links to, if you need a library card to use some of the resources at the library, we have a lot of resources that would help small businesses. And to help you start and manage a small business or nonprofit, you would need a library card to access most of those resources. So I'm going to send you a link for that. And also, if anybody needs assistance with the programs that we have at the library, you can contact us for a book a librarian appointment. And a librarian will sit with you one-on-one to help you answer those questions that you might have. And here's a link to that. And again, I thank you all very much. I hope you've enjoyed this program and for your participation in our Small Business and Nonprofit Expo. Thank you again, Stephanie. It's been a pleasure having you.
It's always a pleasure to work with the library. Have a great day, everyone.
Have a good day.